The Supreme Court just handed down a decision that should be front-page news on every outlet in this country, and instead, most Americans are sitting at home completely in the dark about it. A unanimous 9-0 ruling, every single justice in agreement, that restructures the entire legal framework governing gun rights across all 50 states. Not some states, not the states that already lean a certain way politically, all of them. Every city, every county, every jurisdiction in the United States of America. And if you own a firearm, carry one, or have ever been told you can't, this ruling changes your legal reality. Right now, today. That's what we're covering. A 9-0 Supreme Court decision on gun rights, and what it actually means for the millions of Americans who are going to feel its impact whether they know about it or not. The reason you need to hear this clearly is because the people most affected by rulings like this are the last ones to find out. The attorneys know, the lobbyists know, the politicians scrambling to figure out how to respond already know. But the average gun owner going about their life? They're finding out weeks later, if at all. That stops right now. Before we go any further, if you care about your Second Amendment rights and you want to stay ahead of the legal changes shaping this country in 2026, hit that subscribe button right now. This channel exists for exactly this reason. To cut through the noise and give you the information you need, without the spin, without the delay, without the media filter. Subscribe, turn on notifications, and let's get into it. Here is what you need to understand about how rare this moment actually is. The Supreme Court of the United States is a body built on disagreement. Justices argue, dissent, fracture along ideological lines. That is by design. When you see a 5-4 decision, that's normal. When you see a 6-3, you're watching a country divided in the highest courtroom in the land. But 9-0? Every single justice, the liberals, the conservatives, the moderates, every one of them landed on the same side? That is not normal. That is a statement. That is the court speaking with one voice. And when the Supreme Court speaks with one voice on a constitutional issue this significant, you pay attention. The case itself originated in a single state. One prosecution, one defendant, one state law that served as the vehicle for this ruling. But here is the crucial thing to understand about how Supreme Court decisions work. When the court rules, the ruling doesn't stay in the state where the case originated. It becomes the law of the land. It becomes the constitutional baseline for every court in every state in every jurisdiction across the country. A case that started in one courtroom is now the standard by which thousands of gun laws in all 50 states will be measured going forward. That is the magnitude of what just happened, and that's precisely why it deserves the kind of attention it's not getting from the mainstream press right now. The heart of the ruling centers on what states are and are not constitutionally permitted to do when they create and enforce gun legislation. And this is where it gets real, because the court didn't just rule on one narrow technicality. The court essentially drew a line in the sand and told every state government in the country, you cannot simply invent gun restrictions and call them law. You cannot wave a hand at public safety concerns and expect those concerns alone to justify restrictions on a constitutionally protected right. Every gun law, existing, newly proposed, or currently being enforced, must now pass a specific constitutional test, not a vague one, a rigorous, historically grounded one. And if a law fails that test, it is void. It doesn't matter how long it's been on the books. It doesn't matter how many times it survived previous legal challenges. If it fails the test, it's gone. To fully understand why this ruling matters, you have to go back 2 years to the case that set the stage for everything happening right now. In 2022, the Supreme Court handed down its decision in New York State Rifle and Pistol Association versus Bruen, and that case fundamentally changed the rules of the game for gun law jurisprudence in this country. Before Bruen, courts evaluating gun laws were allowed to use something called interest balancing. That means a judge could look at a restrictive gun law, acknowledge that it burdened your Second Amendment rights, and then essentially ask whether the government's interest in public safety outweighed your constitutional right. And far too often, under that framework, the government won. Judges sided with the state, restrictions stood, and gun owners got the short end of the stick. Bruen threw that entire framework in the trash. The Supreme Court said clearly, you cannot balance away a constitutional right. The Second Amendment is not a suggestion. It is not a privilege that the government doles out when it decides the public safety calculus works out. It is a right, and rights don't get balanced against government interests. What Bruen established instead was a new standard, the historical tradition test. Under that standard, any law restricting Second Amendment rights must be consistent with the nation's historical tradition of firearm regulation. In plain language, if a similar restriction didn't exist when the Second Amendment was written and ratified, the government cannot create one now out of thin air. That was Bruen. That was 2022, and the new 9-0 ruling has just taken that standard and driven it deeper into the constitutional bedrock. The court has now reinforced, strengthened, and universalized the principle Bruen established. It has sent a direct message to state legislatures, city councils, and local governments across the country. Do your historical homework, or your gun laws will not survive. States must now affirmatively prove that their restrictions are consistent with historical tradition. The burden of proof isn't on the gun owner challenging the law, it is on the government defending it. That is a seismic shift in how gun rights litigation works in this country, and most Americans still don't know it happened. Let's bring this down to ground level, because this isn't abstract legal theory. This is your life. This is the carry permit you applied for and got denied. This is the concealed carry license you can't get because your state decided your reason wasn't good enough. This is the law that says you can't carry in a public park, can't carry near a school, can't carry in a restaurant that serves alcohol. These are real restrictions that real Americans run into every single day. And under this new ruling, a significant number of them are now constitutionally exposed. Take the good cause requirement that several states have historically imposed on concealed carry permits. States like California had systems in place where, in order to get a carry permit, you had to prove to a licensing authority that you had a specific documented need for personal protection, not just the general desire to exercise your constitutional right, an actual documented reason. Maybe you'd been threatened, maybe you worked in a dangerous occupation, maybe you could prove you were in special danger. If you couldn't make that case to a government official's satisfaction, you got denied. The Bruen decision in 2022 already struck that kind of requirement down. This new ruling hammers the nail in the coffin. States cannot make you beg for permission to exercise a right the Constitution already guarantees you. Full stop. Or take the example of carrying in public parks. Many states prohibit it outright. Under the old framework, states could justify that restriction as a general public safety measure, and courts would often accept that justification. Under the new standard, the state must now go back through historical records and demonstrate that similar laws existed in the 1700s and 1800s, laws that specifically restricted carrying firearms in spaces equivalent to public parks. If they can't find that historical evidence, the law doesn't hold up. And here's the honest truth. For a vast number of these restrictions, the historical evidence simply does not exist, because during the era when the Second Amendment was ratified, people carried firearms openly and regularly. The legal infrastructure we've built around gun restrictions in the modern era simply has no parallel in that historical period, which means a stunning number of existing gun laws just became legally vulnerable overnight. Now, let's talk about what's already happening in the legal world as a direct consequence of this ruling, because the wave is building and it is going to be enormous. Gun rights organizations across the country were already litigating aggressively under the Bruen standard. The Second Amendment Foundation, the Firearms Policy Coalition, and a growing network of state-level advocacy groups have been filing lawsuits targeting restrictive gun laws in states like California, New York, New Jersey, Maryland, and Massachusetts for the past 2 years. Those states have some of the most sweeping gun regulations in the nation, And those regulations are now staring down the barrel of a reinforced constitutional standard they were never designed to survive. We are talking about assault weapon bans, the kind that classify entire categories of semi-automatic rifles as too dangerous for civilian ownership. We are talking about magazine capacity restrictions that say 10 rounds is the legal limit, as if the Constitution comes with an asterisk. We are talking about red flag laws, which allow courts to strip a person of their firearms based on a petition, sometimes without that person ever having a chance to respond or defend themselves before the guns are taken. We are talking about gun-free school zones and the 1,000-foot restriction radius around schools. We are talking about training requirements that states impose as prerequisites to obtaining carry permits. Every single one of these laws is now a potential target under the historical tradition test, and the attorneys who fight these battles for a living are already loading up their cases. The timeline matters too. We are early in 2026, and the courts are going to be flooded with challenges over the next 6 to 12 months. Some of those challenges will succeed immediately. Others will take years to work through the system, but the direction is unmistakable. The legal trend in this country is bending toward expanded gun rights and shrinking government authority to restrict them. That is not an opinion. That is the documented trajectory of Supreme Court jurisprudence since the Heller decision in 2008, through McDonald in 2010, through Bruen in 2022, and now through this latest 9-0 ruling. Every step has moved in the same direction, and the pace is accelerating. And if you think this is just about the law on paper, think again. This is about people who are sitting in courtrooms right now, facing criminal charges for violating gun laws that may not be able to survive a constitutional challenge. This is about people who were denied permits they had every right to obtain. This is about laws that were passed, enforced, and used to prosecute Americans. And those laws may now be constitutionally invalid. The implications are not hypothetical. They are unfolding in real time. Let's talk about the historical test itself, because understanding how it actually works is the difference between knowing your rights and getting steamrolled by a system that counts on you not knowing them. When a court is now asked to evaluate whether a gun law is constitutional, there's a two-part framework that must be applied. The first question is whether the conduct being regulated, owning a particular firearm, carrying it in a particular place, buying a particular type of ammunition, falls within the scope of the Second Amendment's protection. And in the overwhelming majority of cases, the answer to that first question is yes. The Second Amendment's text protects the right to keep and bear arms. That language is broad, and courts have been increasingly unwilling to carve out large exceptions. The second question is where the real fight happens, and it is where states are going to bleed. The court asks whether there is a well-established historical tradition of regulating this specific type of conduct, not a vague gesture toward the concept of regulation. Actual documented historical regulation from the founding era. Laws, statutes, records from the 1700s and 1800s that show society at the time understood and accepted this specific type of restriction. If the state cannot produce that historical evidence, the law fails. The burden falls entirely on the government, not on you, not on the gun owner. On the government that is trying to restrict your rights. Now, here is the part that should give every gun restriction advocate in this country pause, and every gun owner in this country hope. The historical record from the founding era is sparse when it comes to gun regulation. Background checks didn't exist. Permitting systems didn't exist. Training requirements didn't exist. The concept of a prohibited person, someone legally barred from possessing a firearm, was extremely narrow and applied to very specific categories. The regulatory infrastructure we have built around guns in the 20th and 21st century is largely a modern invention. It emerged in response to modern concerns, and modern concerns, no matter how legitimate they may be from a policy standpoint, do not override constitutional standards. That is what the Supreme Court has now said unanimously, in language that cannot be dismissed or minimized. What this means for prosecutors is equally significant. A prosecutor building a case against a gun owner for violating a specific gun law now faces an additional hurdle they didn't face before. Before they can successfully convict someone of violating a gun law, they need to be confident that the law itself is constitutionally sound under the new historical test. Defense attorneys are going to challenge the constitutionality of the underlying law in every case where there's a viable argument. Some of those challenges are going to succeed. Cases are going to get dismissed. Charges are going to be dropped. People who otherwise would have faced conviction are going to walk out of courtrooms free because the law they were accused of breaking cannot survive constitutional scrutiny. The 9-0 ruling has just made it fundamentally harder to successfully prosecute certain categories of gun cases, and that is not a side effect. It is a direct and intended consequence of how constitutional rights work. There is something else happening beneath the surface of this ruling that deserves to be said plainly. The people who have been writing, enforcing, and defending these gun laws for decades are not sitting still. The political apparatus that has invested years in building the current regulatory framework around firearms is already mobilizing. They are looking for historical evidence to shore up the laws they care about most. They are consulting historians, legal scholars, and archivists trying to find anything in the 18th or 19th century record that might support their restrictions. Some of them will find credible historical analogies. Others will stretch the historical record to the point of absurdity, and courts will have to sort out which analogies are legitimate and which are desperate legal fiction. This means the next phase of this fight is going to happen in courtrooms, and it is going to be messy. Not every court is going to apply the historical tradition test the same way. Some judges will demand a very tight, direct historical parallel. Others will accept broader analogies and give states more room to defend their laws. That variance in judicial application is going to create a patchwork of outcomes across the country in the short term, with different results in different circuits until cases eventually make their way back to the Supreme Court for further clarification. This is the legal process, and it is slow and it is frustrating, but it is also the process by which constitutional principles get hammered into workable doctrine. What you need to understand is that you are living through that process right now, in real time in 2026. The laws that govern your ability to own, carry, and use firearms are in active flux. What is enforceable today in your state may not be enforceable 6 months from now. What you've been told is illegal may shortly be declared unconstitutional. And on the flip side, laws that have been challenged but survived may get a new lease on life if states can produce adequate historical support. This is a dynamic, shifting legal landscape, and the single most dangerous thing you can do as a gun owner is assume that nothing has changed or that this ruling doesn't apply to you. This is exactly why staying informed right now is not optional, and it's why this channel exists. If you haven't subscribed yet, do it right now. We're going to be tracking every major legal development, every significant court ruling, every challenge that lands in a courtroom over the next 12 months. Gun law is changing faster in 2026 than it has at any point in the last century. You need a reliable source that will break these developments down in real language you can actually use. Hit that subscribe button, enable notifications, because the next several months are going to bring more news than most gun owners have seen in a generation, and you need to be ready. So what do you actually do with all of this? What are the concrete steps that a real person, living a real life in a real state with real gun laws, should take right now in response to this ruling? The first thing you do is take stock of the laws in your state. Which restrictions have you been living under that now seem legally vulnerable? Have you been denied a carry permit under a requirement the state may no longer be able to justify? Are you barred from carrying in locations where the state's historical justification is paper-thin? If you live in a state with stringent gun regulations, California, New York, New Jersey, Illinois, Massachusetts, Maryland, you need to pay close attention to the litigation landscape in your state over the coming months. because the laws you've been navigating are squarely in the crosshairs of gun rights organizations that have been waiting for exactly this moment. The second thing you do is talk to a lawyer if you have any active legal issues touching on firearms. If you're facing a charge, a denied permit, a legal dispute over a firearm, or any interaction with the legal system that involves your Second Amendment rights, this ruling is potentially relevant to your situation. Do not assume the government has the last word on what is and isn't constitutional. That is precisely the assumption this ruling exists to challenge. Prosecutors and licensing authorities are going to keep doing what they've always done until they are forced to stop. The only thing that forces them to stop is a legal challenge backed by solid constitutional argument. This ruling gives you that argument. Use it. The third thing, and I cannot overstate how important this is to stop treating your constitutional rights like something the government gives you and can take away whenever it decides the policy calculus has shifted. The Second Amendment does not require the government's permission to exist. It predates the regulatory framework that has been built up around it over the decades, and the Supreme Court, all 9 justices, has now made it dramatically harder for that regulatory framework to stand unless it can prove it has deep historical roots. You are living in a moment where the constitutional pendulum has swung, and the direction it's swinging is toward expanding your rights, not contracting them. But here is the honest reality that nobody likes to say out loud. This victory at the Supreme Court level doesn't mean the battle is over. Not even close. Every institution, every political coalition, every advocacy group that has spent decades building and defending gun restrictions is going to fight back with every tool available. They will fund historical research to support their laws. They will push for new legislation crafted to survive the historical test. They will work to get judges appointed who interpret historical analogies broadly. They will lobby at the federal level for a legislative response. The opposition to expanded gun rights is organized, well-funded, and deeply motivated, and a 9-0 Supreme Court decision is not going to make them fold. It's going to make them fight harder. That's why your vigilance matters. That's why staying informed in 2026 is not a passive act. It is a form of participation in the ongoing constitutional struggle over one of the most fundamental rights in this country. The Supreme Court has issued its ruling. The states are now scrambling to respond. The courts are going to be flooded with challenges. The legal outcomes of those challenges will shape the practical reality of gun ownership in America for the next generation. And every gun owner in this country has a stake in how that plays out. This ruling is a landmark moment, a 9-0 decision that tears down the framework states have been hiding behind to justify restrictions that have no historical basis. A ruling that puts the burden of constitutional proof where it belongs, on the government that is restricting your rights, not on the citizen whose rights are being restricted. A ruling that covers all 50 states, applies to laws already on the books, and fundamentally changes what prosecutors can and cannot do when they go after gun owners. This is not a small development buried in the legal weeds. This is one of the most consequential gun rights decisions in American history, and it happened while most of the country was looking the other way. You now know what happened. You now know why it matters. You know how the historical test works, which laws are most vulnerable, which states are most exposed, and what you should be doing in response. The only question left is whether you act on this information or let it fade into the background noise of a media cycle that never gave it the attention it deserved in the first place. Don't let that happen. Share this with every gun owner you know. Leave a comment below and tell me what state you're in and which laws you want to see challenged under this new standard. I read every single one of those comments, and they directly shape what gets covered next. The legal landscape is shifting. The courts are in motion. And the next 12 months are going to decide a great deal about the scope of your rights going forward. Stay sharp, stay informed, and if you haven't subscribed yet, what are you waiting for? Hit that button right now, because the developments coming out of this ruling over the next several months are going to be impossible to keep up with unless you have a source you trust cutting through the noise for you. This is that source. Now let's make sure you're ready for what comes next.